highly recommend the hour-long video that Kylan had created with them. If you haven't watched it already, I can post it later. It's a YouTube video. It's super helpful. Just something that you can kind of keep in mind later. So I think for the structure then of the call, why don't we do it something like this? Jeffrey and Alex, let's have the AEs that submitted questions ahead of time. Maybe kind of let's let them have preference as far as their questions, and we can, Jeff and Alex, we can, I know the questions, you guys see the questions, so we can just kind of go back and forth, and we can just kind of do it that way. I wasn't sure if you guys just want to maybe take a moment to just introduce yourself, and then do you guys want to just kick off the questions, or would you prefer me to just kind of tell you which ones are now up next?
Yeah, if you could tee them up, that'd be great.
Okay.
But yeah, we get to take a moment. Jeff, why don't you go first?
Hi, everybody. My name's Jeff Bachman. I'm on the business team at Aegis Law. I work a lot with Alex, and I work a lot with Acquira. And, we have helped out on a variety of different types of deals throughout my career. I'm a born and raised guy from Pennsylvania, but I live in the lovely state of Florida, home of the Super Bowl champion Tampa Bay Buccaneers, right here in Tampa, Florida. So I'm enjoying the weather, but I know everybody's all over the place. Just been practicing for about 14 years, wide variety of experiences, a lot of construction law, a lot of business and general counsel work. And now my practice is about half acquisitions and mergers, and the other half general counsel work, kind of helping people post-acquisition with various things they need. And, just enjoying getting to meet so many different people and helping them get off the ground is a great, fun feeling. So I'll let Alex talk a little bit about himself. It's an easy thing for him to do.
Thank you, Jeff, for letting me talk about myself. Jeff and I have a very irreverent relationship. Half of the messages I received from Jeff are him poking fun at me. So if you don't like that, then we're probably not the right team for you. But yeah, Alex Prasad here in, yes, just checking to be sure, cloudy Michigan. That's par for the course this time of year, to be sure. I do not have the pleasure of living in sunny Tampa, which Jeff reminds me of on a multi times per day basis. Yeah, Jeff's experience is really interesting. I've been practicing for about 8 years, and as Amir at Acquira knows, actually, when he's made some handoffs, he will literally say, this is an Alex deal or this is a Jeff deal. So I think we have a good kind of yin and yang. Jeff has a really well-rounded experience for sure, and that construction law really comes in that regulatory background. Though it's mostly in Florida, right? There's analogies for sure in other states. Has been super, super helpful in these. And I have more of a big law background and did a lot of M&A work prior to breaking off and then joining Aegis, which is actually based in St. Louis, though, of course, neither of us are there. So really been a pleasure working with Jeff, with Acquira Kingmakers. And then, we really view our mission as facilitating a deal. And I think that's why we're here, or that's why the relationship grew. I say, and if you look me up, and I really do try to live it, is these deals are 90% human and 10% legal, right? We need to solve for the humans and for the people. If we get the people to agree, the legal will follow. And so that is not a shared ethos, if you will, amongst all attorneys. Probably will see a lot of nods when I say that. And certainly not always shared by opposing counsel or those who are representing a seller, but that's Jeff and my job to manage that relationship. So when I say Jeff or Alex deal, there was one in particular where I'll say it's in West Texas, and the seller's counsel liked bass fishing. Jeff. So we both worked on the deal for sure, but Jeff is the one who connected with this gentleman named Ed. There's one that's happening West Coast right now where the lawyer I say is kind of a fancy pants lawyer. Amir says Alex deal. So they're mutually exclusive lanes, but we really are approaching each of these deals. And of course, and potentially representing you as well, solving for the human, right? What's important for you in the deal? That's the most important thing. We'll obviously provide advice and guidance from the legal perspective, but at the end of the day, we need to understand what you believe is most important. And then importantly, what does the seller believe is most important? Because we need to solve for that too, if we're going to get to the finish line. So just a little bit about us and how Jeff and I work together
Yeah, great intro. Thanks, guys. I did not know that Aegis was out of St. Louis, which is my hometown.
Oh, there you go.
So, okay, let's get back. All right, I'm just going to kind of go down the list here, and
Yeah, we're here. How you
okay,
doing?
sweet. How you doing?
Good.
All right, so Jeff and Alex, let's just tee it up then with Ethan's question. You guys might have it in front of you, but it's
Yes, we're
basically
on.
it's just navigating and mitigating risk for clients buying trade businesses with license requirements.
Want to take first swing, Jeff? I can back clean up.
Yeah, sure. The license, these trade businesses are great. There's a reason why this model is working and everybody's interested in it. Pretty much every single state is going to have some form of license requirement to ensure that you know how to do this thing, or at least you're validly licensing the business. We run into issues because there's always this transition period, because it's typically the seller who's been doing it for 10, 20, 30 years, and the AE's walking into that spot who may or may not have any background in that particular trade. And that's fine. There's nothing wrong with that. What I think, just to kind of more tuned into this question, is if it was me and the other side in your shoes, I'd be looking at one, okay, I'm going to pick a trade that I want and start getting licensed now, or at least understanding what the requirements are. Is it a year, 6 months, 3 months experience requirement? What are the bonding requirements? Do I meet those? The other item I'd note on the licensing is a lot of times the solution to it is to have the seller provide some form of transition services and essentially qualify the business. They attach their business to the license, their license to the business. And there's nothing wrong with that. We just can't do it as an employee if you're going to be SBA financed. That's usually not an issue, to be able to work around that. Or alternatively, a lot of times there's a key employee. And anytime there's a transition, maybe that employee stays, maybe they don't. So up front, we need to identify who's going to be doing that and try to lock them in, because you don't want to end up as an unlicensed business as far as that trade's concerned, post acquisition. That's obviously going to be problematic. And then you have to think about the relationships, 3-6 months post closing, until the license transfers over to you if you're going to do it yourself. Those are the big things and the big discussions we kind of have around that. But I'd really get an understanding of what that licensing requirements are for that particular jurisdiction. Take a look, not just at the state level, but also at the local level, and really deep diving in. This is popping up on a little diligence item for us on a current deal, is if there's any kind of government contracts. So it's not just the trade license, but if there's any kind of certifications, because there's nothing wrong with you buying a women-owned business, but if that's the majority of the revenue and you're a male and you're now over 51%, you're not going to be able to qualify that business for that set aside for that particular government program. Doesn't mean the deal has to stop. It just means that we need to take a look at the financials related to that certification. You're going to see that if anybody does a lot of government contracting on the state, local, or federal level. Those are kind of things I'd be looking out for up front.
That's great. Thank you, Jeff. Yeah, I mean, we're based in Southern California, and from what we can tell, most of the licensing requirements are in the span of years, not months. And given, our focus is more geographic and a little more agnostic as to a specific industry, it's probably unlikely, and also with other commitments, it's probably unlikely that either myself or on this call will be the ones actually getting licensed. And so it seems like probably the key employee is going to be the crucial requirement.
And just like, I'm going to make some generalizations looking at everybody's photos that everybody here has probably worked somewhere else. So you understand there's personal dynamics related to that. You're going to be the new person coming in. A lot of times there's bonuses given out up front. It's just a matter of coming up with a deal to incentivize them to stay on board. And then the other thing I'll say with the licensing too, when you're understanding if you're going to do the key employee route or even the transition services with the seller, is understanding what the license holder needs to do. I can speak to the state of Florida, where there's not a whole lot that practically needs done for the business to be able to pull permits and operate, but the license holder, is supposed to, in some states, go out and inspect every job when it's done. So that might be more services than a seller is willing to do, because hopefully they're getting a nice check from, selling the business to you, and they'll buy. Joke Alex and I were doing, they're going to go buy that bass boat and move to Arkansas. They don't want to come back and inspect job sites that they've done for 20, 30 years. So in that particular one, it was a little bit easier because the licensing requirements were lax, but it's definitely something on a, you add it to the diligence checklist. What do I need to operate here? And also take a look at any expansion plans you have. If you're going to, you may be very familiar with, particularly like San Diego County, but then you go up near the Barstow area where I used to live, it's a very different place than down there. And, so they might have some different requirements that you're not familiar with, and it just kind of crushes your expansion plans. Typically not an issue county by county, but it can be in a highly regulated state. So.
Thank you.
Just a little bit further, right? So zooming out for a second, what are the inputs and restrictions on how we can structure a deal, right? So obviously buyer seller, they have to agree and negotiate. We also have the lender, who can be more or less friendly depending. And then there's SBA guidelines, right? So if I'm going down a rabbit hole, anyone can pull me back, right? But the reason that lenders are making these deals is because the SBA is backing and guaranteeing the loan, in the background, right, to the bank. So they're incentivizing these loans in smaller business transactions, the theory being they wouldn't be done otherwise. Theory, correct or incorrect, that's the way it is, right? So what the lender is doing is two things. One is they're checking their own list, once, twice, three times from a diligence perspective. What do they want to see? But then very importantly, they're cross-checking it against the SBA guidelines. Now, guidelines are guidelines. They're malleable. Certain banks will look more or less closely or favorably on certain situations, right? So one guideline is that sellers should not be involved in the business for longer than a year. Now, it's a guideline. That's a good rule of thumb. We would try to structure something so that they are not involved in the business going forward. Also, different lenders will interpret those guidelines differently. And then there's a different question to be asked about detection. Will they really know? Well, that's a little bit of a dangerous game to play, to be sure, right? Because if you default on the loan, they're going to call it. You're going to have to pay the whole loan, yesterday, right? But those are all inputs into the calculation. So something that we have definitely lived through is getting lenders involved sooner rather than later in the process, even when you're in the LOI stage, to get an understanding of what they believe the pain points are, because it's not black and white. They're guidelines and they're gray, right? And then B, to understand, the ideal situation is when that LOI is signed, there's someone to turn to get that commitment letter, in quite short order. So sorry, related to your question, the SBA will be looking at some of those, transition services, et cetera. And the lender will through the lens of the SBA guidelines. So it's another factor, if you will, into what we can and can't do, or what's advisable and not advisable. That's probably a better way of stating it.
Makes a lot of sense.
Cool. And that's okay, Alex. I figured SBA would get brought up. It does every week. Maybe we'll have an entertaining day sometime where I take a shot every time SBA is mentioned. Turns a big sloppy drunk. But let's stay with the SBA guidelines just for a little bit. I'll ask a question. Can you talk about the liabilities from the SBA loan, like household as a collateral, and if you can also touch on the other questions that's pertaining to situation, and he's here on the call if you need him to elaborate as well.
Yeah, I discussed with Rich yesterday, and Rich, I hope you help me in case my explanation is not completely clear. So in this deal, and I'm going to simplify it, saying that the deal is worth 100, where 10% is coming on, cash, 65% is coming from the SBA loan, leaving a 25% seller financing. So, and that is because 100% of the business has to be purchased as per the SBA guidelines. Mm-hmm. And then at least the way the pre-LOI letter is drafted or was actually sent, the final state is that the seller buys back 20% for a final ownership of 80% for, in this case, me and Acquira, and the other 20% with the seller. So the way of doing that is after the initial sale is complete, the sale back, they are proposing whether it's possible or not do a capitalization, right, of the debt. So if they are going to buy back 20%, that leaves the loan at 5% of because it was an initial loan of 25%. Now that may be difficult because I understand that the loan of the seller will be subordinated to the SBA loan, but capitalization of their loan is possible, or what other vehicles can we have to accomplish the 20%?
You want to take first dibs, Jeff, or you want me to go first?
You can go on that piece. I mean, I can discuss the security issues on it's kind of the two-part question. So.
Yeah. So where to begin? Lots of moving pieces, right? So number one is, well, let's talk about subordination, right, of the seller note. So, and Jeff, check my math. Is it the 10% equity injection is the guideline, right?
Yeah, that's the guideline.
Yeah. Okay. So if in most of these deals, right, there's going to be both the loan from the bank, obviously, and then the seller note. If there is not an equity injection, so cash injection at closing, sorry, I'm going to start high level and then we'll move down, right? At the closing, what will happen is, and it's not happened every time, actually. That's why the guidelines, it's confusing. That's why I was double checking my math with Jeff, right? But the guidelines state that a seller note should be on standby. So not just subordinated, but on standby vis-a-vis the bank note. What does that mean? Until the bank note is fully paid, the seller note could not be paid principal nor interest. Okay, now that's a guideline. Not all lenders, abide by all of these guidelines, right? But that you can go look up the guidelines. That's there. So that's tricky. So you think about a conversation, and we'll get more closer to the heart of your issue, right? And just trying to make it useful for everyone as well, right? That's not very savory. Hey, I'll buy your company, and part of the deal is going to be I owe you this money, but by the way, I'm probably not going to pay it to you for 10 years, right? Until I pay off. That's no good, right? So that requires a greater capital injection to get across that 10% threshold with some lenders. Most lenders, I think, would be a fair statement. Then while the seller note is no longer on standby in that situation, so you'll be paying both notes at the same time, it is still subordinated. So it is actually, funny is the wrong word, but how much time we spend on the seller note and securitization, because really at the end of the day, if the deal goes sideways, we don't want to talk about it, but it is a potential outcome of these transactions, right? 90% or 80%, whatever the math is, the lion's share of whatever's left of this business that needs to be liquidated is going to the bank lender, not to the seller. So, we'll spend the time there. Seller obviously wants to be sure they get paid that amount, but in reality, just again, level setting expectations, sellers, that note is kind of is a very much disfavored situation, right? Okay, so now closer, and maybe I'll hand the baton here to Jeff in just a second, but closer to your situation, there will be loan covenants that state that the ownership of the company looks like X, right? We're going to make those promises to a lender at closing. We know in the Acquira model that we're going to change likely the ownership of that company shortly after closing, right? Depending on who you are and how aggressive or not aggressive you are, you could say, whoa, that's in violation of these covenants. This is a bad thing, right? Lender would look disfavorably on it. And from a technical perspective, that's probably true. So that the fact pattern that you're describing is kind of doubling down, if you will, on that structure. So again, just putting all those cards out there. I think, in various educational formats, we're aware of this. Our position, without, writing you a legal opinion and charging you all the fund malpractice, that would come from that, and, CYA is, Acquira's, injection, that's actually a good thing for the company, right? So if when a bank says, oh, wait, hey, however they discover or detect, this is a technical breach of our loan, we say, yeah, but the company's better, not worse capitalized now, and we're still paying you. Okay, that's so we've not considered, and Jeff, here's where I'll hand the baton to you, whether to double down on that model with seller coming back. That to me starts to increase their risk profile, because in terms of guidelines, we're kind of lighting up a Christmas tree of additional guidelines that we are running afoul of. But Jeff, I'll
Fully understood. And the reason for that to be, and it's also part of the conversation with investment committee, is to have the owners around for longer than 12 months because of the nature of the business. So the key here for me is that even with a 20%, keep a controlling interest by myself, right?
Mm-hmm.
And that's the only reason, because the other option to that is, purchase 100% of the business and no sale back, which increases, the likely of the owners not staying around after 6 or 12 months.
Well, hey, Jeff, talk about a little bit the royalty idea they've been kicking around on another deal. That's maybe a solution.
Yeah, so we've done a lot of research into this issue, because one of the fun parts about working with between Alex and I is we're not deal killer mentality. A lot of attorneys, they want to. I swear they have a vested interest in making a deal stop, and so we tend to get very creative. But there's some realities and some hard stops, and then there's guidelines that we try to work in. So we keep trying to figure out this kind of solution, because we have these incentives like you're talking about, Daniel, where we want the seller on board for a period of time, but we want them to be incentivized, but we also can't give them pure equity because of the SBA. That's going to be a specific SBA rule in that case. So how do we do this? So we've been discussing a form of royalties or percentage of the gross, and not necessarily sharing in pure profits that would satisfy certain lenders, because then we get into interpretation issue. So it's one thing to have an option where out of the 100 shares they get 20 of them at the end of X period for this amount, or in exchange for this amount of services, some form of typical traditional earnout. We know that those are very frowned upon, and we're going to have a hard time unless we get a lender that's just haven't found one yet. I'll put it to you this way, that will work within that. So we're starting to kick around the idea of doing a form of royalty or fee sharing agreement, specifically if we need them to come back in and be heavily involved versus, kind of a static thing. And, even on the creativity side of that is, let's, perhaps do some pro formas and estimate what those revenues are. And maybe it's not a pure percentage. And we kind of figure out what an equivalent flat fee or hourly rate might be for those services, some form of contingency. It's a matter of shifting that risk. It's always tough with that. But
okay, well, thank you very much for the responses. I think we should have additional conversation, right? Because the pre-LOI letter was presented as explained it, and probably we should have got this conversation before presenting the pre-LOI, because that is going to work against our I guess seriousness as buyers, but that does, at the end, it's already done, the pre-LOI presented. So if we're going to make modifications of the deal structure, let's get together, schedule some time or some conference with you to engage in business and present something that is attractive for the sellers, because I want to dress the deal around their wishes, so they're willing to sell to me, right? Which has been, conversation has been great. They gave me feedback during the visit, and however, there's no formality yet, right? So it means that they can still talk to others, which may mean higher prices or so. So the faster we move, the better. So let's leave this question and conversation here now. So we have the opportunity to hear other questions as well, and I guess we'll be talking later. Thank you.
Thank you. And I'll send you their contact information, and vice versa. Okay, so next up, this question, actually it's a three-part question coming from in the Northwest, I believe. What is typically best, stock sale or asset sale? First question. Second question is, what is the best way to limit lawsuits from the previous owner? Third question, what is the best corporate structure for a business with an SED of $1 million that plans to acquire more companies? And at what point does a corporation make sense? Is on the call, by the way, if he needs to add more to that.
Well, that's the next half hour. No, I'm joking. So there's a lot of things. The first one is asset sale versus stock sale, right? Is that right? Right, the first question. Okay, so birds and bees here. I'll try to be light and fluffy, right, just to give you the true North Star, and certainly, happy further deeper conversations. So asset sale, right? We're buying the stuff. Okay, I mean, yeah, no doubt, Alex. Trust me, you get better detail, right? We're buying the stuff. We're not buying the box that the stuff is in. So the box is the company. You go with me here, whether it's an LLC or a C corp, and then there's stuff inside. So we're going to go in that box, grab what we want, potentially exclude certain things. The liabilities are staying there, right? And we're going to take that bundle of goods and go off on our merry way as an acquirer. Okay. Stock sale, give me the whole box. Okay. So positives of acquiring just the things. Asset sale is the liabilities potentially, well, it's got to be a cash-free, debt-free deal. We'll do lien searches, et cetera, to ensure that there are no liens attached to the things that you're getting, right? But we can take those things, put them into a new box. That would be your acquiring entity. Off we go. Theoretically, the chain has been broken, if you will. So those liabilities stay in the old box. That's seller's responsibility. You have a clean slate. Second reason that an asset deal can be positive for an acquirer, and this is me inching out onto the limb because I'm a lawyer, not an accountant, and Jeff and I are very much both those things and not the other. It's though there are other resources to acquire, right, that can help us in making this decision. Is you can depreciate those assets potentially over time. How much depends on the target. Is there, how do we do the math to determine whether that's worthwhile or not? Beyond my scope, though I can speak intelligently enough about it to be dangerous, right? Okay, so that's asset sale. Stock sale, you're taking the whole thing. Well, why would you do that? Well, number one, there are some tax elections that we can make to treat the acquisition like a stock sale. So you get the stepped up basis to depreciate over time, right? Tax benefit there, but allow seller to treat it as the sale of his or her shares. Seller wants that because they get capital gains tax treatment on the sale of stock. So you can see this tension here that in general, a buyer wants assets, and in general, the seller wants to sell shares. And so the tax benefit, and also seller wants to be like, liabilities, goodbye, see you later, right? And it's buyer's problem. And this is a long answer to this first question, but two things to keep in mind. Number one, when we do this transaction, risk is not eliminated. So get that for anybody, get that out of your head would be my advice, right? We're just shifting risk. So we will spend, I promise you, if and when we get to engage on a deal together, a lot of time on where does that risk shift? What's fair? What's reasonable? And Jeff and I, through our experiences and the collective US experience on acquisitions, know what's quote unquote market and what's standard, right? In general, we're going to do a cash-free, debt-free deal, meaning as of the closing, there's a big line in the sand. After the closing, it's buyer's responsibility. Prior, it's seller's responsibility. Plenty of nuance there. That's one point. And I think I had a brilliant second point, but I think I'm forgetting it. But cash-free, debt-free. Oh, and then it's indemnification. We'll spend a lot of time and effort on caps and baskets. What's a reasonable amount of liability for seller to retain in an asset or a stock sale? And what's not. And then to wrap up the very long answer to the question number one is no matter what we write down on a piece of paper, this goes back to the human element, right? People can sue. I could sue any of you tomorrow and it's not a threat. Well, take that out of context in this recording when no clients, right? But just because we've written down and agreed to an infrastructure doesn't necessarily mean that people will abide by it, right? So we're going to try to set the rules of the game if and when there's a dispute. It's not inoculation against future issues, to be sure, right? And unfortunately, Jeff and I, in our experiences, have seen some pretty wild fact patterns of people being just basically complete jerks. And no matter how well you structured for that, even if you kind of had an inkling or anticipation, it won't be prophylactic, right? We can't stop that before the damage is done, but we can set the rules for the game and feel confident about what that would play out as, after the fact. It's a limited powers as a business attorney. Okay, that was number one. Jeff, number two. Do you remember number two, Jeff, is the first
Yeah,
question?
I do. I do. And then it's kind of a more of a clarification, Greg, is are you worried about lawsuits? You say lawsuits from previous owners, that lawsuits against the company or the lawsuit from the previous owner on you as the buyer?
Mostly like lawsuits from against the company or from within the company.
Okay. Yep. Perfect. Great question. Like Alex said, is there a way to get rid of all liability? Nope. What we can do is acknowledge it and figure out where they are and see how to deal with each and every single one. So first way is asset sale versus stock sale. He just talked about that. We're going to buy the assets and exclude liabilities. Is it perfect? Nope, but it'll get you pretty far because we're not taking that lock, stock, and barrel approach. We're not getting that single box. Another method we use is a thing called representations and warranties. So our purchase agreements, they all contain them. And this is just a promise or a statement from the seller saying, here is what it looks like. This is, if we think about it, maybe from a car we purchased. I just bought a car on some online app and they have the little pictures and they say, here's the defects. It's disclosures, so you're going to take it subject to this defect, or I'm going to say that this is perfectly fine. We have benefit plans, but I've paid it all. I've paid all the taxes. Everything through this date is done. There are no lawsuits pending. There's none of this stuff. And that's all contained in the reps and warranties. Another mechanism is your own inspection. It's easy to find out if there's a pending lawsuit. What we're really concerned about is there's a hidden fact pattern somewhere that somebody's mad about something and the seller didn't tell you. Similar to buying a piece of real estate and you discover something buried in the backyard or there's mold in the house, things that are kind of these latent defects that we don't understand, and due diligence is not perfect, but it's designed to kind of ferret some of that out. So that's another mechanism that we can use, so either whether you're doing it yourself or you hire some professionals to kind of dig through that. Those are all mechanisms on doing that. Another one is Alex alluded to it a little bit, is the indemnification. So even if what you tell me is incorrect, you're going to pay me back. You're going to hold me harmless for these things. Now, nobody wants to do that 100%, so they'll put caps on it. They'll say, hey, don't bother me if there's a problem and it's super small, or we have 5 small things and we put it in the basket and then we pay you back, and how that occurs. Those are some of the big ways that we're acknowledging that there's risk there, but we're creating some kind of mechanism to shift it back the other way. And that's where, honestly, we spend a lot of our time. And it's never perfect. You always wonder, are they just being overly protective? Are they being paranoid? Or are they hiding something? And it's difficult. And that's where, honestly, our success with the AEs has been in their relationship with the seller. Because a lot of times that human element, we're discovering that, okay, this is just lawyers doing lawyer things. And we raise this up to our clients. They go and talk to the seller. And sometimes they come back and they say, well, I don't know. But honestly, most of them are really good about understanding. They're like, no, that's just this guy. He's worried about this because he's got a litigation background, whatever. And I took a look at this thing. Oh, or it's like, hey, I need to dig into that a little bit more because they were awfully silent about that, so those are all processes and kind of mechanisms we do to limit those possibility of that lawsuit. The last one I wanted to mention is the statute of limitations. So that's a big one, so after a certain point, you don't have to worry about it. And so as you're digging through on due diligence and saying, okay, wait a minute, what's my concern here? Oh, well, they have 30 people working there, but they're all independent contractors. And I can assure you, if you're in a trade business, they're probably not all independent contractors. That just may be the way they save some money along the way. So, okay, we need to acknowledge that risk, or maybe it still incentivizes us to buy it because of that. But we're either going to have them indemnify that specifically, represent that this is lawful, or we see that the statute of limitations, let's just, and it's jurisdiction by jurisdiction, is 5 years. So we know for a period of 5 years that we have this risk hanging out there because we're taking it all at post-closing. But, if there's something that pops up pre-closing, when's the cutoff? And we just kind of look at that. Those are all different mechanisms, when you're thinking about how to limit the possibility of a lawsuit.
Thank you. Thank you so much. That's really helpful.
And if I can add, Greg has a third question, and it's about corporate structure and the best way to structure the business, and also has a question surrounding that. So the pros and cons of each. And I realize this is probably extreme expertise within our team, but Alex and Jeff, if you can provide commentary around that, that'd be helpful too.
Yeah, I'll take a first swing. Here's your lawyer answer, the most lawyer answer of the day. It depends. So, what we'll do for step one is probably the simplest thing possible, right? You probably form an LLC, and assuming single member, we have some forms off the shelf because we're repeat service providers, if you will, in terms of how to structure that relationship with Acquira going forward. By the way, we'll talk about the inherent conflict there because we do work with Acquira, right? And we'll upfront when we potentially engage with you. So we'll address that absolutely upfront in a transparent way. Long term, again, there's going to be a lot of considerations, right? So likely, let's say you're going to do this in a serial fashion, we may create wholly owned subsidiaries where the top company, if you will, is a holding company, which all it does is hold shares of each of various companies. And so then we're creating more boxes, right, that are cabined off and are completely separate. So they might be called what we call brother and sister, sibling organizations, but they actually have it might be Greg, right, ultimately owner across these, but they are separate. If there is one of these latent lawsuits, if you will, that we stub our toe on in one, no effect on the others from a corporate structure standpoint. Setting that up ahead of time, not necessarily required, right? We can restructure that and move those things around. From a tax perspective, we'd want to get the right minds there to make sure that what we're doing is optimal tax-wise, kind of different analysis. But nothing that you were to wind up, if you will, on transaction number one would prohibit or cut you off on transaction 2, 3, or 4. We could kind of grow that infrastructure over time. And I say crawl, walk, run a lot. And, metaphor I like to use is, on one side of a neck of woods, right? How are we going to get there? If it's just you're just going to walk, right? You don't even need a path necessarily. You got to move a wind turbine, different story. We're going to pave a 8-lane highway, et cetera. We can get there and we can build up that infrastructure as time goes on. But first crack at it, if you will, good thing to keep in mind. No, that's coming, but probably don't need, you can convert LLCs into C Corps, vice versa. I mean, there's all these, mechanisms that we can do. So you're not locked in or, predestined to a particular result based just on the first deal.
Greg, good.
Thank you.
Yes, very helpful. Thank you.
Okay, excellent.
Yes, I'm here. Hi.
I tell you what, rather than
You can read my, I'm driving though.
Okay, you want me to read it then?
You
Okay.
can read it. Yeah.
Okay. All right. You kind of wrote you wrote a chapter of a book here, but I'll do my best.
But I got to do the answer.
You want me to just say it? All right.
I am playing with you. You know that.
All right. All right. Accused of writing dissertations. It's true.
Jeff or Alex, do you guys want to? You have it in front of you. Do you want to kind of maybe paraphrase it?
Yeah, I can
Okay.
jump on this one, Alex.
Thanks.
Basically, if I'm understanding correctly, Tanya, you have an existing business. It's called X. You want to buy the assets of another business, Y, and you need to know, do I need to change the name, EIN? How do we do this? Do I keep using the same bank accounts, employees? How does all that shift from point A to point B, which it happens quite often, but if you've never done it before, it can be very confusing. So based on that, the short answer is you don't really need to change anything. You can add, because you're buying the assets, one of the pieces of property that you're buying is the trade name. Okay, so one of the things we're going to be looking at, or you should look at as part of your due diligence, is how is this trade name registered? Is it trademarked? Is it registered as a fictitious name or a doing business as in that particular jurisdiction? And how do I attach it to my business? Most times this is actually a fairly simple thing. So you could keep calling it Rempert Inc., doing business as, Palm Beach Air Conditioning, whatever the particular business is. And you're just simply attaching that alias. My full name is Jeffrey. People only call me that when they're picking on me, or like Alex does, or if I'm in trouble. But, I go by Jeff. It's just an alias to the business. So we're attaching it. What that allows you to do is keep the same history. If you have to worry about your business credit, or you want to keep that, you have the same records, you keep the same EIN. So nothing really changes except for what the name you're operating under. Now you had kind of a part B on there, which is a good one too, is, what if I'm going to have a subsequent acquisition using the same funds from this business? And that's where really kind of Alex kind of hit on that earlier, is does it make sense from a functional, operational, or legal standpoint to start segregating these? And, honestly, that's a really case by case, it depends answer, but can you do it? Yes. That's the short answer. Absolutely, you can do it. You could even attach a second trade name to your existing corporation. Should you do it? We got to kind of sit down and figure out the numbers and say, does this make sense from a tax standpoint, from an accounting standpoint? Do I need to keep two sets of books? Does that all make sense? It's pretty easy to set up a separate company, and I generally like to do that just for segregating liabilities. Do you have to? No, but you kind of run it that way as well.
Thank you. I have another question.
Yeah, go ahead,
I was told, so they accepted my offer, and the broker said that I needed an attorney who could practice in New Hampshire. Is that true? Can you guys practice in New Hampshire? So that's my last question.
Jeff is available to go to New Hampshire like November to March. But when the weather is nice, he won't go there. No, it's a joke. Go ahead, Jeff. You can finish off.
The short answer is, if it involves any kind of real estate transaction, a lot of times what we do is we get local counsel to kind of hand out a closing there. If there's super state specific stuff, then a lot of times we'll work with local counsel. How often does that happen? 5% of the time. It's a contract. It really depends on the governing law. Are there specific regulatory issues? Most of the Acquira deals, that has not been an issue. Are we allowed to? Absolutely, as because you're not in that state, so so unless we're doing litigation there, which hopefully we're not, and it won't be me, I don't need to be licensed there. So that's a short, like I said, the only time it's really popped up is where we needed a quick opinion on a definition on, say, a licensing thing. I think that's the only time it's really popped up, in one closing that involved a piece of real estate they were purchasing, not just leasing. I believe that was the only times we've had a retained local counsel, if I remember, Alex, or work with local counsel.
Yeah.
So if it definitely includes real estate, then would you say that it matters, or just work with you guys and you'll just find me a lawyer for the closing type thing?
Yeah, real estate's real estate. I'm not drafting a New Hampshire deed. I'm not going to draft a New Hampshire mortgage. Now, what happens most times is we work with the seller's counsel who is there. They're more than happy to draft it, and we mark it up. Most of those terms are not, terribly different, unless they have a crazy tax structure, which really, again, we had this happen in Texas, and instead of calling it a mortgage, they call it a deed of trust. I know what a deed of trust is. How do they apportion taxes and prorate them in the state of Texas? It's not difficult to find that out. Most of your purchases, most of the AEs most of the businesses that you AEs are looking at are not terribly complicated. As far as, we're not buying a 100-acre industrial complex where we got crazy hazmat issues to worry about. It's typically a smaller lots, single purpose, single function type business. So yeah, it's usually not a problem. And like I said, we've worked with local counsel. They're isolated, segregated issues that we need to bring them in. very, not too often, 5% of the time.
Yeah, just 30 seconds on this because it comes up all the time, and it just makes me smile. Is, you know, there's many types of attorneys, but there's basically two. There's transactional attorneys and litigators, and litigators take up all the oxygen on the room. They're the ones that are on Law and Order, etc. Those are the ones. You know, I live in Southeast Michigan, right? If I drive 30 minutes south from my house, I'm in Ohio. God forbid. Sorry, friends are from Ohio. Not sorry. I'm a Michigan fan, so Ohio is the worst state in the union by far. It is unarguable. Anyway, I can't do anything as a litigator attorney. I had to squeeze that in Ohio. Like, you know, literally 10 feet across the border, completely useless. My license, I can't walk into a courtroom and present myself, so on and so forth. And so litigator, 100% true. That's where that idea comes from. So it's not the wrong idea. It's not like categorically incorrect, right? It's not quite true in business transactions. By the way, we're probably going to choose a law that's neutral to govern our documents, that especially if it's an interstate deal, as in not the buyer state nor the seller state. And usually we default to Delaware for very rich case law there, et cetera. So to Jeff's point, when there are jurisdiction specific issues, we're going to find out the answer. And if we cannot, we'll be the first to say, hey, there is this complex thing that we don't understand. It would be better to XYZ, right? We will wave that flag. But in general, the blocking and tackling of these deals is not, I mean, I spent at my former firm on a deal with 8 zeros, 7 zeros, too many zeros, in my opinion. I was in Orange County, California for 7 weeks as a Michigan attorney working on a deal. So it's not a foreign concept, big or small deal. It's our litigator friends, I'll say, friends in quotes, that have driven that misconception because it does apply to them.
Perfect. Thanks, guys. Great question. Up next, we have, he would like to know, how do I keep legal actually, him and everybody else more than likely wants to know this. How do we keep legal costs down during due diligence? And what are the legal aspects that an AE should be aware of before, during, and after an acquisition? I think that's a super awesome question. Before, during, and after an acquisition, where should our headspace be with regards to legal?
You want to take first swing, Jeff, or do you want me to?
Yeah, you know, that's the fun part about Alex and I. We both approach things from different directions, so it gives you different points of view. Neither of them are incorrect. I'm probably a little more right than he is sometimes, but depends on your view. I'm a Penn State guy, so you know we have a little bit of a Big Ten in-house rivalry going. How to keep how to keep the cost down, you know. So one of the things we've done with Acquira is we've kind of set a certain amount, and we work off a flat fee, so that you don't have to worry about that. And you know, we've done enough of these, we know about what that number is for one of these acquisitions. So we, you know, also take a certain amount of risk on the deal too. So you know, that's one thing that we do in general as far as diligence, whether you're doing it with yourself, because your time is worth money, you know, so there's that cost too. Whether you hire an outside professional in tax, finance, whatever, is being clear on what you're concerned about, being upfront with yourself. And if you are a person that kind of walks around thinking the sky is going to fall at any given moment, for any given reason, entrepreneurship is probably not an avenue you should go down. But most of us are not like that. You probably wouldn't be in the gauntlet or having gone through the gauntlet if that's the way you were. So it's being clear, hey, listen, I'm worried about employment. I'm really concerned about these contracts. I'm really concerned more about the finances. This other stuff will shake out. You know, being very clear, that way you can isolate and segregate and, you know, focus your diligence efforts onto the things that really are concerned. Now, a lot of that has to do with your visits and discussions with the seller on figuring out what those are. And if you've been around people long enough, you'll know what they kind of avoid and what they're not advertising, and asking those questions. One of the things we've done in the past is we kind of arm our clients with a due diligence checklist, because it's, you know, the most dangerous question is the one you didn't even know to ask, you know, so is figuring those things out and, you know, judging your satisfaction based on their initial responses. And that kind of lets you know where you want to dig, you know. So that's kind of the before and Now the during is really where it gets difficult, whether you're working with us or working with somebody else, because time is, most lawyers are going to bill by the hour. And our experience with sellers counsel has been that they are more than happy to spend a lot of time on these deals. And usually they're competent. Sometimes they're not. And I don't say that as a knock on them. Sometimes they're in a small town and it's the guy who did the wills, the guy who did the bankruptcies, who's now trying to help his friend that he grew up with acquire a business for a couple $1 million. You'll get people who aren't familiar with SBA guidelines and certain lending requirements that are pushing things that aren't even going to be permitted, So getting your sellers to work with competent counsel saves everybody time, saves everybody a lot of heartache. I think that's probably the number one killer right there, honestly, from our standpoint. Afterwards, it runs the gamut, and that really just depends on your comfort with that particular industry, how much you're working with the seller on any kind of transition services. Again, that's why I said half my practice is probably general counsel, because I'll get calls afterwards from somebody we helped out on a deal, like, hey, I'm looking for this warranty. Can you draft this up for me? I need an employment agreement because we brought on another salesperson, things like that. And that's just, it's no different than any other business. I think it goes a little bit easier with a lot of times because I've gotten to know that particular buyer through the process, and I kind of know what their risk tolerances are and how they like to operate, and that saves everybody a lot of time, and it's frankly a lot more enjoyable because I love transaction work because we get to see a seller going off and enjoying the fruits of their labor that they just did for 20 years, and a lot of them it's a retirement fund, so getting to help out even when it's not my client is enjoyable. And then the happiness that comes from buyers when they finally get this dream, this goal, this thing they've been working at for so long. I really enjoy that part of it. And then the kind of the mix is I don't get to talk to them afterwards unless they call me up for something. So I love working with them post acquisition as well on the general counsel side, because it's like, this worked out exactly as we had, or this was not what we thought it was when I got in there, but it's okay because I, X, Y, and Z, and it's always been a lot of fun. It's been very enjoyable. So Alex, I didn't know if you want to chime in on that at all.
There's one point on the kind of the during, which I think speaks to the before too, is we have to be super clear about our roles. You all are the principals and we are the agents. There's only so much that we can do for you to get the deal done. It's not like, it's 501, see you later. No, that's not what I mean. What I mean is you really own the relationship, and you own the relationship with the seller. And so, if we get the chance to work with you, you will hear me say over and over again, like, what does sellers say when you're having conversations with seller? Forget their counsel. So, legal ethics, I can't communicate with seller without seller's counsel being involved, right? And so that's a real rate limiting factor, to be sure, but understand why those rules are in place and certainly respect them, right? But I'll give you a great example from a deal, this West Texas deal we were telling you about, in terms of there's only so much I can do. And so we're going to coach you and get you to the finish line, but we are the football coach, not the running back, right? We were kind of down to, Jeff, you fact check me here, right? We were down to the last, 2 or 3 issues. They were super remote because this guy was a bankruptcy seller's counsel, was a bankruptcy guy. And so he's all worried about the bankruptcy situation. And again, based on subordination, et cetera, we're talking about pennies on a dollar max, like in the best case scenario, maybe tenths of a penny, on a dollar worse, right? A really esoteric from our perspective of getting the deal done, and low probability, low, value driving results, right? That he was worried about. But it was loggerheads because seller's counsel was doing his job, or thought he was doing his job. In my opinion, wasn't serving his client well, but that's neither here nor there. I'm on the other side of the fence, right? And so, Jeff, you remember, it was fun because it worked out, right? Half hour, 45-minute conversation with the AE in that situation where we coached, was his name, to go talk to seller and say, look, what do you think the issue is here? I know your counsel saying X, Y, Z, but seller, I'm going to bet you $1. I think I said this directly. Seller can't articulate what the issue is. It's because it's pretty esoteric, right? So there are very, very few sellers. If you grow some steel in your spine here, put some steel in your spine and say, look, we've been at this for months. It's been kind of a wild ride. I'm kind of, at the end of my rope. He was, because lender wasn't going to budge on this issue. There was not flexibility. So you need to present to seller more or less to take it or leave it. I mean, have the conversation. You built a lot of trust, a well of trust here. That's why you can have this conversation with seller. But you got to say, if we can't get over this hump, I'm probably done. I told 99.9% of the time when you say someone $3.2 million or this thing that you don't quite understand, that seems like it's a really remote chance, and you can be in Arkansas. This was this guy's better than Ohio, but it was like the seller's dream situation. The guy said yes, right? They dropped that issue and we got to the finish line. That I think was, Jeff and I discussed afterwards that we felt good about that. We're not the principal. We didn't cause that to happen, but just from having seen the movie enough times or many times, we're able to coach the buyer, and they're in the captain's seat, right? They're driving the deal. We're there to help coach, give the playbook, et cetera. But at the end of the day, it's up to buyer and seller to work together to execute and tell us, how to best serve them. So that's a great way to keep costs down, because when it's just us talking to seller's counsel, not that that's not productive sometimes, right? We're not going to solve anything. We're going to find things out and then make a recommendation to buyer or seller respectively. But we're not going to ever solve an issue, because we don't have the authority to do that. That's your job, right? You get to make the decision or empower us to say yes or no to certain things, right? But we're not going to make that decision for you. That wouldn't serve you well. You need to be fully, read in and understand it, and then tell us, how we're going to execute on it.
You guys okay with answering just one more question? I realize we're at the, okay, fantastic. And then before we have a question, I think this definitely needs a part 2 with you guys, maybe like in a month or something, or a few weeks, if you guys would be open to it, because I have a feeling we probably have a lot more questions that AEs are going to want to ask on top of this. So
happy to. I'm
awesome.
More different than Jeff, though. Jeff, are you willing?
Yeah, definitely. I love that's part of the fun.
Yeah, that's fantastic. Thanks, guys. Okay, I'm going to turn this over to you. The last question. It's about PPP.
Hi, guys. Try to be brief, but maybe it's a little bit wordy. Anyways, so as you may know, today was the deadline as an extension of round 2 PPP funds of CARES Act. If I'm looking to make an offer like now on a transaction, we've got an escrow period. So the seller just applied for the round 2. He got approved. He hasn't received the funds yet. It's almost 200 grand, so it's material. I guess the question is, on the legal aspect, is there provisions in the note that account for transition of ownership and where those funds could go, and or forgiveness repayment conditions? I guess and the second part might be any color around negotiating that with the seller if it's not legal, kind of leverage I have to try to get those funds, or really, I shouldn't even be asking if they were kind of associated with 2020 operations.
Jeff, drive it home.
Yeah, so one thing with the PPP too, and I won't say this definitively, I won't promise my first child, maybe the second one, I think it got extended to May 31st on the application period. Yeah, I think it looks like that just happened today. I saw it on LinkedIn, and I just Googled it while we were talking.
Okay.
So that gives a little more time. So how do they deal with that? So the company got a loan that's going to be forgiven. This has happened a couple times over the past year. That's specifically going to be an issue on a stock purchase, because we're taking on the liability. So your SBA lender, if you're working with the SBA, or if it's a different lender, they're going to want the same thing. Yep, they're going to say the same thing. That's fine, but you're going to put that money in escrow, seller, and you're going to do what's called a holdback, and you set that money aside in a, we do the escrow agent too sometimes. We set it aside, and here's the condition. You're going to wait until you get a nice little release of escrow from the or whoever did the PPP loan, and at that point you get it back. So it might be 6 months, 8 months, whatever, on the forgiveness. And usually the seller is very incentivized at that point, because they want this pot of money to go back, because we are buying it, typically cash-free, debt-free. They want that to go back in their pocket. So they usually work with you. So it's not really been a big issue. It's just more of being aware that it exists, and that's not often a disclosure problem. We're going through it right now. We got a pending deal That's pretty much how we're going to handle it. Just put it in escrow and wait for the forgiveness letter and then release it to the seller.
So forgiveness, and then the money goes to the seller. No argument about, hey, what if the new strain comes out? What if there's another government shutdown? What if there's no extra PPP funds? He didn't use the funds, obviously, because he's getting the money now. We're transferring the business. I don't know.
Okay, no, I mean, that's a good follow-up question is, that's with the PPP loans, there's going to be your typical representation, that the SBA lender is going to want, that these things you did use the proceeds and they are capable of being forgiven. But here's the thing, PPP loans are a little bit different because we're doing a dollar for dollar payback. We don't have to worry about accrued interest and things like that unless we keep it or didn't use it for that. So, if they're wrong, if the seller's wrong, we essentially have a pre-built indemnification. What's the easiest way to get rid of a PPP loan? You give the money back, so we have that set aside out of their proceeds. So, that's why it's not typically too big of an issue.
Okay, I think I got the gist of it. Thank you.
Okay, that's a close. Thanks everyone for submitting questions. And I know there's probably more that we need to get to, but Jeff and Alex, let's talk offline and get another date rescheduled in a few weeks to do this again.
We'd love to. That'd be great.
Okay,
Cool.
fantastic. All right, really appreciate it.
Thanks
Thanks, guys. See you next week.
Thank you.